What happens when family court orders are breached? And what should you do next? If parenting orders are being violated right now, the next step you need to take matters because the wrong reaction can hurt your outcome in court. After handling hundreds of family law cases, I've seen the same pattern repeatedly. Parents either escalate too quickly or wait too long, and both approaches damage their credibility with the court. Just last month, we worked with a parent who had documented 12 breaches over 6 months, but made 3 critical mistakes that almost cost them from their case. So in the next few minutes, I'm going to show you the exact triage system courts expect you to follow, what qualifies as a reasonable excuse that protects the other parent, and the 3 credibility killers that sabotage even strong breach cases. Before I show you what to do, you need to understand what's at stake when you get this wrong. Most parents think documenting breaches is enough. They screenshot text messages, they keep a diary, they reach out to lawyers. But here's what actually happens when you don't follow the right pathway. You withhold changeover in retaliation, thinking you are standing your ground. The court sees this as you becoming part of the problem. You send aggressive messages out of frustration. These messages get submitted as evidence of your inability to co-parent. You file an urgent contravention application for what the court considers a minor one-off breach. And now you've just wasted thousands of dollars and damaged your credibility for future applications. If you don't believe me, the maths is brutal. For example, the legal costs for a rushed contravention application start at $5,000 to $10,000. If the court finds you escalated unnecessarily, you could be ordered to pay the other party's cost as well. More importantly, you've also signaled to the court that you can't manage conflict appropriately. That assessment follows you into every future parenting matter. But here's what most people get wrong. Not all breaches are equal, and not all breaches require court intervention. The court expects you to use a triage system. Think of it like medical triage. Urgent breaches require immediate court action. For example, if a child hasn't been returned, there's a safety concern, or someone has taken the child out of the country without permission. For these situations, you file a recovery order. This authorizes police to locate and return the child. Without this court order, police treat it as a civil matter and won't intervene. Serious or repeated breaches need documentation and escalation too. This includes patterns like consistently withholding changeover, repeatedly not facilitating phone calls, or refusing makeup time. This is the moment you should consider a contravention application. These are quasi-criminal proceedings with serious penalties, including fines of up to $13,320 per breach, community service, or even up to 12 months imprisonment in extreme cases. If the case is minor or it's a one-off breach, always try to resolve it through communication first. So before you do anything, ask yourself, is this an ongoing pattern or an isolated incident? Is there a safety risk? Have I tried to resolve this through communication first? The court will ask you these same questions. So if you can't demonstrate that you tried to communicate and try all other responses first, your application will look premature and potentially unnecessary. Now here's the insider detail that most parents miss, and it's the difference between a successful breach case and one that gets dismissed. It's not just about proving the breach happened. You need to demonstrate positive action. Here's what that actually looks like in practice. Before handover, you talk about the upcoming visit in an encouraging way. You help the child pack in an upbeat manner. You never ask, do you want to go, in front of the other parent, because that sets up failure. During handover, you attend every single time, and even if the child refused previously, you actively encourage the child to go. You speak positively about the other parent and the time they'll spend together. Keep the whole experience neutral, enjoyable, and stress-free, even if it's not how you feel. After visit, you ask enthusiastically, you went to the zoo? That's awesome. What animals did you see? You focus on positive aspects. Parents have an active obligation to positively encourage contact. Simply saying I tried but they didn't want to go is insufficient. And if you can, demonstrate positive action even when facing breaches from the other side. You become the reasonable parent in the court's eyes. So start keeping a log right now. Date, time, your positive actions, the breach that occurred, and your response. This documentation combined with evidence of your positive action is what wins breach cases. Now, there are 3 mistakes that will damage your case, even when the other parent is clearly in the wrong. And if you make these, here's what happens. Red flag 1, retaliatory withholding. The other parent doesn't return the child on time, so you withhold the next changeover to teach them a lesson. You've now breached the orders. The court sees 2 parents who can't comply, not 1 victim and 1 offender. Red flag number 2, emotional documentation. Your breach log says things like, she's deliberately trying to hurt me, or he's a terrible parent. The court wants objective facts, so log things like, child was due to be returned at 6 p.m. as per orders. Actual return time was 9:15 p.m. Text message evidence attached. Document what happened, when, who witnessed it, and your response. Save the emotional commentary for your therapist, not your court documents. Red flag number 3, calling police for non-emergencies. Having police attend for disputes where children are present when it's not necessary is called systems abuse. You're exposing children to conflict with police involved. Once police are called, they have a duty to notify child protection authorities. Now you've escalated a parenting dispute into a child safety matter. If you must breach orders for genuine safety reasons, here's what to do immediately. Call 000 if there's an immediate danger. Document everything right away with specific details about why you believe the breach was necessary to protect. Contact a lawyer within 24 to 48 hours. Apply for urgent court orders if the threat is ongoing. Notify child protection authorities if there's abuse or family violence. And remember, the legal standard for reasonable excuse requires 2 things. You believed on reasonable grounds that preventing contact was necessary to protect someone's health or safety, and the breach period didn't last longer than necessary. Your subjective belief that you are acting in the child's best interest is not enough. You need objectively reasonable grounds, and you must take legal action promptly. You now understand the triage system the court expects, what constitutes positive action, and the mistakes that damage your credibility. But here's the reality. Breach cases are often symptoms of a larger communication breakdown. That's why understanding the myths surrounding family cases is so critical. So watch this next video where I break down the biggest repeated factors I see in family law cases, what the reality actually is, and how you can avoid costly mistakes along the way. If you are dealing with breaches right now and need specific advice for your situation, we offer strategy consultations where we review your documentation, assess your options, and create a clear action plan. The link is below.